Hello everyone, my name is Natasha. I'm currently studying for a degree called a DPhil in law, also known as a PhD in law at the law faculty. And I'm also a college lecturer at Keble College, where I'm a tutor in constitutional law. I was previously an undergraduate student at Oxford, where I studied for the undergraduate degree, the undergraduate law degree, BA Jurisprudence. So I have been in your position as a prospective applicant, and I'm delighted that so many of you are able to join us this afternoon. My presentation will be on an aspect of human rights law, and I will speak for, I think, around 40 to 45 minutes, and I'll try to leave some time for Q&A if there are any questions at the end. And as Emma said, please feel free to pop any questions in the Q&A box, and if there are any, I'll do my best at the end of the presentation to answer them. So I'm just going to try and share my screen. There we go. Hopefully you can all see a presentation slide there. So the topic of my presentation today is human rights in times of crisis. And I chose this topic for a few reasons. First, students of human rights law tend typically to be interested in the scope of protection of human rights. And times of crisis pose serious challenges for the protection of human rights. And these instances can also help us to work out the scope or boundaries of legal protection of these interests. Second, this topic enables us to consider a case study from the reading list for the undergraduate human rights law course. And thirdly, my DPhil research touches on this question in various ways, and I also thought the subject might be of some topical interest. So without further ado, here is the outline for the presentation today. First, I will say a few words about what studying human rights law at Oxford entails and how I came to focus on this subject in my undergraduate studies, my work and research. Second, I will give an introduction to human rights law, what it is and how it has developed. Third, we will look at a couple of human rights instruments that are of particular importance for the UK. Fourth, we will analyse the legal mechanism found in a number of human rights treaties designed to protect human rights while providing states with some extra flexibility in times of conflict and crisis. Excuse me. And that provision is the derogation clause. And I will explain more about what derogation is and how the clause works in due course. Fifth, as I mentioned, we will consider a case study concerning derogation, drawing on a case from the undergraduate human rights law course reading list. The case is called A and Home Secretary in the domestic courts, and the same case also known as A and the United Kingdom when it progressed up to the European Court of Human Rights. And finally, we will have a look at some recent practice of states, a number of states that have had recourse to the derogation clause when seeking to justify measures, restrictive measures adopted in the light of the COVID-19 pandemic. So, to the first point, what does studying human rights law at Oxford entail? In the first year of the BA Jurisprudence degree, undergraduate students study constitutional law as a compulsory course. And broadly speaking, constitutional law concerns the relationships between different institutions of the state, Parliament, the government, and the courts, and the scope of what each of them can do. Domestic human rights law forms part of that course. So we look, for example, at certain provisions of the Human Rights Act and what the UK courts can do if they decide that a law is not compatible with human rights. For those interested in learning about human rights law in more detail, there is an optional course in third year specifically on human rights law, and that course is usually very popular. So in that third year option course, students learn more about the rights themselves, and they read and evaluate the decisions of the European Court of Human Rights, considering whether they are coherent, problematic, etc. It's worth noting here, I think, that each university will organise its teaching differently, and you should read the prospectus for the relevant law course that you're applying to in order to find out which subjects are compulsory, how many option subjects you can take, and so on. I think it may still be 2 option subjects for your, excuse me, for the Oxford Law course. Other universities may offer more or less. So just check before you, when you're applying. So for me, I studied, of course, the human rights topics in constitutional law as a first-year undergraduate, and I thought that the topic was very interesting and I wanted to learn more about it. So I then took the optional course in third year, and that's when I really got to grips with the subject and really thought, this is fascinating, I really loved this. I found reading the case law and thinking about the dilemmas which arise really fascinating and just very enriching. And I enjoyed it so much that I stayed on to do a master's degree in law with subjects focusing predominantly on human rights and international law. I then left Oxford to train as a solicitor, and that was in the vastly different field of corporate and commercial law, which was a very good experience, but not ultimately the area of law that I wanted to focus on. Subsequently, I trained as a barrister, and there I was able to work more closely with public law and human rights. But ultimately, I came back to Oxford because apparently they can't get rid of me. And I'm now conducting research which focuses specifically on international law and human rights. So that covers the ways in which you can study human rights law as an undergraduate at Oxford, and how my interest in human rights law developed. And I mentioned a little bit about my backstory there too, just in case any of you would like to ask questions about, for example, what it's like studying as an undergraduate or working in law, etc. So please do feel free to pop any of those queries in the Q&A, and I'll do my best to answer any. Okay, the second topic in our outline is an introduction to human rights law. The moral justification for protecting human rights is a very interesting philosophical debate, but we don't have too much time to delve too deeply into that here, and we will focus our attention on the development of human rights law. And the idea behind protecting certain important interests from interference by powerful institutions has a long history. The history of this idea can be traced, for example, back to Magna Carta, a royal charter signed in 1215. Excuse me. Here we see King John of England signing the document, which granted a number of rights and privileges to groups of noblemen. Most provisions of Magna Carta consequently did not confer human rights in the modern day, in the modern day sense of the term, as we would understand it. For one thing, that's because most of its clauses were limited in application to a small group of the nobility. Some of the clauses could be said to have broader application, but as we will discuss, modern human rights laws tend to be more detailed and aim to be more systematic in their protection of human rights than those provisions. And as this quote from Hirsch Lauterpacht, a prominent human rights lawyer, shows, what we see here is the early development of the idea that there should be limits on supreme power, in those days the power of the king, and it was this idea of conditioning coercive power which became a force in history. Fast forward several centuries, and we have World War II and the birth of the modern international human rights law movement. And there had been a number of significant developments in the interim. We won't go into much detail about those, but the experience of the Second World War and the atrocities of the Holocaust prompted a number of states to develop a shared understanding of minimum standards of rights which could be ascribed to individuals by virtue of their humanity. In 1948, a committee within the United Nations produced an important document, the Universal Declaration of Human Rights, held in the image there by one of the key people involved in its drafting, Eleanor Roosevelt. And here we have an attempt to set out universal rights and freedoms of all human beings. The declaration was adopted by the United Nations General Assembly, but its provisions were not legally binding. And this meant that individuals could not go to courts to claim that their rights under the declaration had been breached, and the courts could do nothing about it if they were, absent any other legal mechanisms for redress. Further developments in the 1950s and 60s eventually brought forth legally binding treaties concerning human rights. And we will focus on this treaty, the European Convention on Human Rights, often abbreviated to the ECHR or the Convention. The UK is a party to the ECHR, This treaty contains a derogation clause, which we will come on to consider in due course, and certain rights in the ECHR are also given effect in UK law in a number of ways through the Human Rights Act, which we will come to consider. The European Convention on Human Rights is a product of the Council of Europe, an institution which is completely separate from the European Union. So consequently, even though the UK has now left the EU, we remain signed up to the ECHR, though there have been some calls for us to withdraw from that treaty too. The ECHR also came with a new court. The European Court of Human Rights was created by the Convention, and it is the body which can ultimately give authoritative interpretations of the Convention rights. So that is the treaty infrastructure for the Human Rights Convention. But what rights do we actually have that are recognised in international law? What rights would you expect to see in a treaty of this kind? What rights do you think you have? Well, let's find out some of the sorts of rights that we have under this treaty. Here is a list of rights in the European Convention on Human Rights. There are some additional protocols which states can sign up to optionally if they choose to, which include further rights, but I haven't included those here. Hopefully some of these will be either familiar to you or rights that you would expect to see in an international human rights treaty. So, for example, we have the right to life, freedom from torture, the right to liberty, freedom of expression, freedom from discrimination, the right to a fair trial, etc. And these kinds of rights have traditionally been categorized as civil and political rights. They can be compared, for example, with a different category, economic, social, and cultural rights. And the latter category has been interpreted to include rights such as the rights to food and water or an adequate standard of living, to use the treaty terminology, the rights to health and to housing. And those kind of rights are the subject of different treaties. Legal theorists have postulated different views about the nature of rights. And one prominent contribution to that literature is on the correlation between rights and duties. One theorist, Wesley Newcomb Hofeld, argued that where one person has a right, which he termed a claim right, another person has a correlative duty. And applying this to human rights law, this means that when we have a right, the state has a correlative duty either to do something to secure the right for us or to refrain from doing things which would violate that right. And some human rights provisions have built-in express limitations, circumstances in which the duty bearer, the state, can lawfully interfere with our rights without breaching its legal duties. So let's look at an example of this. Freedom of assembly, Article 11 of the European Convention on Human Rights. The green text highlighted here sets out the right in the first paragraph. Everyone has the right to freedom of peaceful assembly. The red text tells us that the state can limit the enjoyment of the right. It says no restrictions other than those prescribed by law and necessary in a democratic society. The text highlighted in yellow here tells us the purposes for which the right can be limited. So free assembly can be restricted in the interest of national security, public safety, preventing crime, or protecting the health, morals, or rights of others, so long as any such restrictions are prescribed by law and necessary in a democratic society. And this has been interpreted to set a standard of proportionality. Does the state's interference with the right to free assembly, or is the interference by the state with the right to free assembly proportionate? Does it use the least restrictive means, i.e. the means to achieve the aims in yellow that are the least restrictive of the right? Or do the means used go too far to achieve the aims in the yellow text? And this is just one example of a right with limitations. The different rights in the treaty will have different structures, and some admitted more limitations than others. Here, for example, we have freedom from torture, Article 3 of the European Convention on Human Rights, which is not qualified in the same way that Article 11 is qualified. So this provision states simply, no one shall be subjected to torture or inhuman or degrading treatment or punishment, and there's no second paragraph which includes those express limitations. But I wanted to introduce the idea of limitation because in exceptional circumstances, states may decide that they need to go further than what is permitted even under these limitations. Just before we get on to that, I wanted to finish setting out the relevant instruments by mentioning the Human Rights Act. The Human Rights Act was enacted by Parliament in 1998. It gives effect in domestic law to a number of the convention rights referred to on the previous slide in a few different ways. And here we have photographs of the Royal Courts of Justice on a nice sunny day, and one of the courtrooms, I think it's courtroom 1 of the UK Supreme Court, both in London, where cases concerning human rights issues are often heard. And a key purpose of the Human Rights Act was to enable people to assert and rely on convention rights in our domestic courts without having to incur the extra time and expense of going to the European Court of Human Rights, which sits in Strasbourg, to vindicate their rights. But where an individual believes that their convention rights have been violated and that they have not been able to get a remedy from the domestic courts, they are still able to apply to the European Court of Human Rights once all of the domestic remedy options have been exhausted, and so long as they meet various other criteria. And here we have a photo of the court, the European Court of Human Rights, and its rather space-age looking building, and an image of one of its courtrooms. This provision in the Human Rights Act, Section 1, states that the named articles in the European Convention are to have effect for the purposes of the Act, subject to any designated derogation under Section 14. And we will come back to designated derogation in our case study, but first we need to explore what we mean by derogation. In general, derogation means to move away from or to impair something. I think more people tend to be familiar with the related term derogatory. So if you speak about something in a derogatory manner, you seek to or have the effect of undermining or weakening that thing. And I think we can see a bit of an analogy with the way that the term derogation is generally used. And in a legal context, derogating means modifying or curtailing the application of a law. In the particular context of human rights treaties, derogation is a mechanism which conditions the instances in which states can adopt measures that would, under normal circumstances, violate their duties to protect human rights. Excuse me. So the derogation clause permits states to do things that they are not normally permitted to do, so long as the circumstances meet and the state complies with and the measures comply with the conditions in the derogation clause. Here is the text of the derogation clause, which is included in the European Convention on Human Rights, Article 15. This provision sets out the circumstances in which states can take restrictive measures going beyond limitations in times of war or other public emergency threatening the life of the nation without violating the state's legal duties. And as you can see, the provision is divided into 3 parts. The first paragraph sets out a number of threshold and limiting conditions that the prevailing circumstances or the measures adopted by the state must meet if the derogation is going to be valid and enable the state to take restrictive measures without violating its obligations under the treaty. For example, in that first paragraph, there must be a war or other public emergency threatening the life of the nation, and the measures adopted must be strictly required by the exigencies of the situation, where it says the state may take measures derogating from its obligations to the extent strictly required by the exigencies of the situation. The second paragraph there lists a number of rights from which no derogation is permissible. These are sometimes termed the so-called non-derogable rights. And they include Article 3, freedom from torture. So as we noted earlier, Article 3 is not subject to express limitation in normal times, and nor is torture permitted in times of war or emergencies. And the third paragraph there sets out a process for states parties to the treaty to notify each other when they are taking measures derogating what they believe to be measures derogating from their duties under the treaty, and the reasons for those measures. So to illustrate this concept further, I thought it might be useful to see some examples of derogations in the real world. And these are 3 examples taken from different human rights treaties concerning different events around the world. On the left, we have a derogation from the European Convention on Human Rights made by Turkey in 2016. The reason given for the derogation notice in that case was an attempted coup d'etat, aiming to overthrow the government of Turkey. In the middle, we have a derogation from a different human rights treaty, the International Covenant on Civil and Political Rights, made by Guatemala, or the notice was given by Guatemala in 2010, following the eruption of the Pacaya volcano. And the state, in that case, restricted rights to free movement and to free assembly in certain areas in order to minimize the danger. On the right, we have a derogation from the American Convention on Human Rights made by the Dominican Republic in March 2020. And that notice concerns restrictive measures adopted by the state to tackle the spread of COVID-19. And we'll say a few more words on COVID-19 derogations later. So as we can see, derogation can be triggered in response to a variety of circumstances. And the examples I give here of the reasons for derogation are not exhaustive. But now we know what derogation is and when it can be called into aid by a state to take exceptionally restrictive measures. But what happens when those measures are challenged, when those measures which we call derogation measures, what happens when they are challenged by the individuals who are subject to the measures? It's here that the courts can become involved, and this is the context for our case study. Excuse me. So the case we will analyse is called A and Home Secretary in the domestic courts, and as I mentioned, the same case referred to as A in the United Kingdom in the European Court of Human Rights. This case concerned a derogation from Article 5 ECHR, the right to liberty and security of person. And to understand the context of this case, we need to go back to 2001. In 2001, there was a large-scale terrorist attack in the United States of America, entailing significant loss of life. The event became known as 9/11 because it occurred on the 11th of September. The UK, a prominent ally of the USA, perceived there to be a risk of terrorist activity or connected terrorist activity on domestic UK soil. And consequently, the UK government decided to adopt certain restrictive measures, and Parliament agreed to enact certain restrictive measures, which I will outline in a moment, and to notify those measures as derogation measures under the European Convention on Human Rights. The Home Secretary, a member of the government, also made a designated derogation order under Section 14 of the Human Rights Act relating to those restrictive measures. And the text that you see on the screen there is part of the UK's derogation notice. So as you can see from the red highlighting, the state claimed that as a result of this, the events that were prevailing at the time, there was a public emergency threatening the life of the nation in the UK. And to address the perceived threat, Parliament enacted a new law, the Anti-Terrorism, Crime and Security Act 2001. This provision of the Act, Section 23, permitted the detention of certain persons certified by the Home Secretary as suspected international terrorists. And this applied only to people who were subject to immigration control, i.e. only to foreign national terrorist suspects and not suspects with British nationality. As you can see from this red text, when suspects could not be removed or deported, they could be detained temporarily or indefinitely. And that means that they could be imprisoned, locked up with no end date to their detention. This raised a potential issue for the UK's ability to achieve or adhere to its duties under Article 5 of the European Convention on Human Rights, the right to liberty. Article 5 sets out the right to liberty, and part of the text of that provision is on the screen there. The issue in this case, was that the limitation to this right in the yellow text at the bottom of the screen there, so Article 5(1) subparagraph F, this limitation permitted detention only when action was being taken against a person with a view to their deportation. And that was not the case for people detained under Section 23 of the 2001 Act, who could be detained despite the fact that they were not able to be removed, whether that was for legal reasons or practical considerations. Back to the UK's derogation notice here. So here we have the state, the UK, recognising that some cases of detention under the 2001 Act may not be consistent with its duties to respect the right to liberty under Article 5, and in particular may not be consistent with Article 5(1)(f). And consequently, the notice states that the UK is availing itself of the derogation provision, Article 15 of the Convention, so that people could be detained in line with Section 23 of the 2001 Act, even though doing so without a derogation would likely have violated the right to liberty under Article 5. This detention regime was challenged in the case of A and Home Secretary. A and the other claimants were a number of detainees who challenged the designated derogation order made by the Home Secretary and the related legislation. In 2004, the case came before the UK's highest court, then known as the House of Lords and now known as the UK Supreme Court. The claimants made various arguments, but we will focus on two of them. They argued first that there was not a public emergency threatening the life of the nation, and that's the first condition in bold in Article 15(1) there on the screen. Second, the claimants argued that the detention regime was not strictly required by the exigencies of the situation, and that's the second condition in bold in Article 15(1). So, question 1. Was there a public emergency threatening the life of the nation in the UK in 2001? Bear in mind that there had been no attack relating specifically to 9/11 on UK soil at that time, but the UK was a close ally of the USA. So what do you think the court decided? Was there a public emergency threatening the life of the nation? Well, a majority of the judges were prepared to accept the government's argument that there was a public emergency threatening the life of the nation in the UK in 2001. Lord Bingham, one of the majority judges, stated that great weight needed to be given to the judgment of politicians on questions such as this. Compare that with the view of another judge, Lord Hoffman. He concluded that the threat of serious violence did not amount to a public emergency threatening the life of the nation. He considered that the threat would have to be so fundamental as to threaten our institutions of government or our existence as a civil community, so a more serious threat if it was going to qualify as the relevant threat under Article 15. But he was alone in that view, in his view about the threshold for the condition here. So a majority of the court agreed with the government on this point, that there was a public emergency threatening the life of the nation within the meaning of Article 15. What about the second argument? Was the detention regime strictly required by the exigencies of the situation? And to answer this question, a number of the judges found this evidence to be influential. Excuse me. The evidence was that the threat posed was not limited to arising from foreign national terrorist suspects who were subject to the 2001 Act detention regime, but the threat also came from British national terrorist suspects who were not subject to the detention regime. What do you think the judges? What view do you think the judges came to about whether the regime was strictly required on the basis of this evidence? A majority concluded that the detention regime was not strictly required by the exigencies of the situation. Here is another quote from Lord Bingham, who's in the majority. He was not convinced that indefinitely detaining foreign national terrorist suspects when the threat also came from others was strictly required. And a majority also concluded that the measures were discriminatory on the ground of nationality, and there had been no derogation from freedom from discrimination, which is protected under Article 15 of the ECHR. One judge, however, disagreed with the conclusions of the majority on discrimination and the strict necessity of the measures. And the dissenting judge, Lord Walker, considered that it was for Parliament and the government, rather than the courts, to judge the response necessary to protect the security of the public, and concluded that the detention regime in the 2001 Act included adequate safeguards and was strictly required. But as he was alone in this view, the majority decision is the one that prevailed. And this meant that the designated derogation order made by the Home Secretary was quashed by the court, so it was made invalid and of no effect. And the 2001 Act was declared to be incompatible with convention rights under Section 4 of the Human Rights Act. But that kind of declaration under Section 4 does not invalidate the law, the relevant parts of the 2001 Act in any way. It just indicates to the political actors that the court considers that the law is incompatible with convention rights. So the claimants remained in detention, and they applied to the European Court of Human Rights. In this case, known as A and UK, the Grand Chamber of the European Court of Human Rights substantially agreed with the decision of the House of Lords. The European Court of Human Rights held, firstly, that the detention regime did not fall within the exception to the right to liberty. So it was not a permissible deprivation of liberty under Article 5.1f, didn't fall within that limitation, because no action was being taken with a view to deport the individuals detained under the relevant section of the 2001 Act. Secondly, the court held that there was, or accepted that there was, a public emergency threatening the life of the nation. But thirdly, the court decided that the derogating measures were disproportionate in that they discriminated unjustifiably between British nationals and non-nationals. And consequently, the derogation which had been notified by the UK was not valid in respect to this provision. And as a result, there had been a violation of the right to liberty under Article 5. Prior to this decision, however, Parliament had in fact changed the law, repealing the 2001 Act and brought in a new legal regime. So that was our case study on derogation under the ECHR, a detention regime adopted in what was accepted to be a time of emergency, which both the House of Lords in the UK and the European Court of Human Rights decided was not compatible with the human rights, with the convention rights. And have a think about the debate between the majority and the minority. Who do you think should be judging or assessing the necessity of the measures adopted in response to emergencies? Is this properly a matter we should leave to politicians, or should judges be making decisions on these matters? Have a think. Before concluding, I just wanted to mention some recent state practice concerning derogation, which has arisen from or in light of the COVID-19 pandemic. A number of states have notified derogations to deal with the spread of COVID-19, and many of those derogations notified named restrictions on freedom of movement and school closures as the relevant restrictive measures, which were considered to be derogation measures. Here we have a few examples of a number of European states which sent notifications of derogation in respect of measures brought in to tackle the spread of COVID-19. Though some of these derogation notices have since been withdrawn as states rapidly change the legal rules regulating what individuals can do. But I thought it might be interesting and illustrative to see an example of a derogation notice concerning COVID-19. So here we have an example of a derogation notice about COVID-19 submitted by Estonia to the Secretary General of the Council of Europe. So this is a derogation notice given under Article 15 of the European Convention on Human Rights. The yellow text here shows the reason for the state's notification relating to COVID-19 and the threats posed to public health. It also shows the start date and the anticipated end date of the derogation. This blue text highlights part of a summary of the derogation measures taken by the state. For example, it lists the closure of schools, a prohibition on public gatherings, and restrictions on free movement. The green text here helpfully indicates which convention rights the state believes may be subject to derogation because of the restrictive measures. And the orange highlighting here excuse me, demonstrates that the state has attached the text of any new legislation or administrative orders relating to the derogation. And I think what this example shows is that one thing a derogation clause can do is to provide a kind of transparency at the international level when states deem it necessary to adopt measures that are restrictive of rights, which they believe may involve derogation from their duties in times of public emergency. What about the UK? The UK has not notified a derogation or not submitted a derogation notification in respect of measures taken in response to the COVID-19 pandemic. And we can speculate about why that might be. It's possible that the government or its advisors believe that its measures fall within permissible limitations. There did seem to be some confusion about whether a court could notify such a derogation in the case of BP and Surrey County Council. This case concerned an 83-year-old man who lived in a care home, whose daughter wanted him to be released to stay with her during lockdown, but the care home declined to permit that and suspended visitations. It was argued that this action was a disproportionate interference with the man's right to liberty. And the judge in this case initially appeared to suggest that there needed to be a derogation and that the court could justify it. And that's the part of the effect of the text there. Derogation becomes not only justified but essential, and I will send notification of my decision. But later on, the judge, following argument from the parties, reneged on that view, considering that only a high contracting party, representatives of the state, and by that I think he may mean the representative of the government of the state, can notify derogation, and the court could not. So what I think this shows is that there are many interesting questions which remain to be worked out about derogation. It's a live and a practical issue, and it's one that I find absolutely fascinating to study and to research on this topic. So for anyone who is interested in further reading on human rights law, here are some options for you to look at. The Oxford Human Rights Hub has a library of materials, including a blog, some videos and podcasts, and these are on some really, really engaging topics. I should perhaps declare a slight conflict of interest, as I occasionally edit the blog posts that are received by the Oxford Human Rights Hub, and I have hosted one or two of the podcasts. But they're great fun to do, and fortunately for me, I get to have some really interesting discussions with some people working on fascinating things. And so that's can be a good option to think about, or get to think about some topics that do not fall within your sort of general day-to-day work. And the Bonavero Institute of Human Rights also hosts some very engaging public events, I think all on Zoom at the moment. And you can also find some very intriguing recorded lectures on podcasts.ox.ac.uk. And when I was applying to study law, I listened to one or two of these podcasts in order to get an idea of what it would be like studying law, what some of the topics would be covered. So I can recommend that from personal experience. So that concludes my presentation. I think we do have some time for if there are any questions. So if you do have questions about human rights law, what it's like studying law at university in general or at Oxford in particular, do feel free to pop them in the Q&A box and I will do my best to answer them. But otherwise, thank you very much for listening this afternoon, and I hope you enjoyed the remainder of the taster day. And thank you, Emma, for managing everything.
No worries. Thank you very much, Natasha. Really interesting. We've got less questions than yesterday, but that's all good. And there's some quite good ones though, considering how few they are. I don't know if you want to go. You can see them, can't you?
I'll just have a look now. Is it, yeah, the three in the Q&A box?
Yeah.
Yeah. Okay, great. Would you like me to just work through a few of them?
Yeah. If that's all good with you.
Yeah, that sounds good.
On the chat as well, because I think some people are in there too.
Thank you very much. So one of the questions is, do you feel that the 2020 Coronavirus Act is an impeachment on our rights? So I think there have been a number of different pieces of legislation concerning COVID-19 and the state's measures to control the spread of it. So there are different. It's hard to give a particular view in a very general way, because you have to, if you're assessing the human rights compatibility of a piece of legislation, you really need to look in particular detail at what a particular provision is, so a relevant section of an act and its effect, and how it's affecting people, in the community. And so it's very hard to give a kind of answer in the abstract, if that makes sense. But I think there certainly have been some challenges on human rights grounds to some of the restrictions that have been brought in, and I suspect those kinds of challenges will probably continue while we are all subject to restrictive measures. And of course, one of the unusual things really is that this is one of the first times, I think, in the lives of most of us that we are subject to such severe restrictions that are imposed on us by the state. And obviously it's for a legitimate reason. It's to contain the spread of the virus and to protect public health. And these kinds of interests, people's individual rights and the necessity of the need for protecting public health. These are the kind of interests that are going to need to be balanced by courts deciding, making decisions about whether legislative provisions and actions of the government do breach human rights in these cases. But I'm afraid it's very, very difficult to comment in the abstract, and I think easier to think about whether, think about it in particular context when you're assessing a specific law. I hope that's okay, that answer. So we seem to have a few more questions now, which is quite helpful.
Yeah.
Okay, I'll try and rattle through some of these then. Is it possible to derogate rights in perpetuo or for an unspecified time? So, the idea behind the derogation clause is to limit the circumstances or limit the measures that can be taken in derogation for the duty. So remember that restrictive measures can only be permitted under the derogation to the extent that they are strictly required by the exigencies of the situation. And so if the exigencies of the situation become less severe, the measures become, which may have been justified at one point in time, no longer remain justified. So if the circumstances that require or may require the derogation measures to be adopted ease, then the justification for taking those measures goes away. And once the measures become unjustified, what we have then is a limitation on rights that is not justified under a specific limitation, nor is it justified under the derogation clause, and that becomes a violation of human rights. So the part of the purpose of the convention, or of this article of the convention, Article 15 of the Human Rights Act, and other derogation clauses under different treaties, is to try and limit the extent to which there can be long-running restrictive measures that are restrictive of rights. But of course, if crises run on for a very long time, then and the measures are justified for a very long time, then derogations can last for a very long time. And there were a number of, I think, at least one, or I think a number of derogations made in respect by the UK in respect of the Troubles in Northern Ireland, and those measures spanned a number of years, 20 years or more. So it's not always the case that there will be or that there is a clear end date for the measures, but part of the purpose of the way that the clause is phrased aims to restrict the time that, or at least aims to ensure that derogation measures cannot be taken if they are no longer justified by the circumstances. Thank you for your question. Okay, let's see. Emma, if you see any ones you particularly think would be helpful to answer, that would be...
Yeah, sure.
Rather just reading through.
Oh, here's a good one for you, because you were both solicitor and barrister. So do you feel like your work as a solicitor gave you an advantage in academia?
Oh, that's a good question. Thank you. Well, I think there are many academics who don't practice, and I don't think they're any the worse off for it, because there are very different skills that are involved, really. But I do think that my practical experience, or the practical experience that I had, came about for relatively pragmatic reasons. But I do think it has been of some benefit to me to have seen the way that the law works in practice, because you can kind of understand, or you have a different approach to it in some ways. You when you're a practicing lawyer, you have to act for a client, and so you take whatever argument your client wants to make, or at least you take the outcome that they want to achieve, and then your job is to arrange the arguments in such a way that you can help your client to achieve the outcome that they want. And that's the case whether you're a solicitor assessing the case for the first time, or whether you're a barrister who's arguing the case in court or giving specific advice about the merits of the case. So when you're a practicing solicitor, you're acting on behalf, or a practicing barrister, you're acting on behalf of the client. And that means that you come at the issues in a particular way, and you think about them in a very, what I hope would be kind of a lawyerly way. Whereas academics can have a bit more of a sort of step back overview and a rounded view of both arguments, and can kind of make decisions about whether they think the law in that area is justified, or is a good thing, or needs or ought to be changed, or is problematic in any way. Whereas for an advocate, a practicing advocate, the question of changing of the law is not really forefront in their mind, unless they want the Supreme Court to overrule a previous decision, for example. Their focus is really acting for their client. And so they're quite different approaches. But I think the best solicitors and barristers will think, what's my best argument? What's my client's best argument? What are the other side going to argue? And how do we counter that? So they need to think of both sides too. And then when you're an academic, you think about the same kinds of things, I think, but you also get the luxury of being more of an independent third party who can take an overview of, or take a view on the law as it stands, and whether it could be better in various ways. It's a bit of a roundabout way of saying, I think it's not necessary, I guess, to be an academic to have had some experience of practicing law, but I think it has opened my eyes to the different kinds of arguments that you need to make, and the way that when you're reading legal decisions, you're reading the judge's conclusions having heard the argument of counsel, and based on the work of solicitors. And so I think having some insight into it for me has been useful, but it's certainly not necessary. I think it's a slightly unusual career path to take, but I'm not complaining about it.
There's another one about careers, actually. So it says, what careers could you pursue directly with human rights?
Oh, this is a good question. So there are a number. There's, of course, human rights, or solicitor who works in human rights law, and often solicitors and barristers will cover a range of different practical areas. So some of them may have a specialist practice in human rights law, but they will also work in, for example, employment law or media law, thinking about free speech and privacy. They may have a specific specialism within the category of human rights law. So they may do lots of community care type cases. They may do welfare benefits challenges type cases. It can be really varied, and the bucket of human rights law, I think, to some extent is very wide, and so it just depends on what kind of work that you do. But a number of solicitors firms and a number of barristers chambers advertise themselves as accepting that kind of work or seeking that kind of work, and are specialised in work that involves human rights law and other things. And so one way to work in that field is to apply to a firm or a chambers that does that kind of work. But I think it is worth noting, probably will end up doing other kinds of work too. And certainly to some extent, people do tend to subsidize human rights work with other forms of work. And then the other options, though, are working, well, as academia too, obviously, just as an alternative example. And then another option that's less well known, I think, is working for a human rights charity, or some organisations that tend to bring public interest litigation on human rights grounds. So a number of charities will occasionally apply for standing in a legal case to challenge a decision, or will intervene as a third party in an ongoing legal case, making human rights arguments. So there are jobs as a legal advisor in one of those kinds of roles, where you can get involved with writing submissions and collecting evidence that the charity can usefully provide to the court about how a particular law or a particular measure is affecting people in the community. So I think it can come up in a lot of different fields, and I think the thing to do is think about what kind of work that you want to do and where your skills might be well suited. And one thing I would say is that sometimes you may take a bit of a winding route. I think many people these days don't start a job and then stay in that job for, in perpetuity. So it may be that you move between a few different roles, but do try and think what you'd like to do and try and go for that. I think that's the best advice.
Going back to the case study that you just did, so there's a question saying, do you agree with the majority concerning the case study? So what's your proper opinion of it?
Yeah, this is a great question. So A in UK is a really good case to read, and A in Home Secretaries are the same case. Is a really good case to read, I think. I think so. It's important to bear in mind the balance that needs to be struck here, and I understand very much the need to, or the pressures that states and politicians come under when they are concerned about the risk of national security. Fully understand that. I do think, though, that this was a relatively clear example of disproportionality, because the way that the balance had been struck in the legislation could not be justified by focusing on one particular group to the exclusion of another group. And what I think, or the function that I think courts usefully perform in this sphere, is requiring the political bodies, the bodies that make this, that strike the laws, strike the balance of the laws, to really think about and justify the decisions that they make. And if those decisions go too far in trying to achieve, the definitely legitimate aim, then that is a legitimate circumstance, I think, in which the courts can and should say, we don't think that this can be justified. And they're not saying that, you must, the courts don't say you must have the law as this, you must change the law to this, but that's not their role. Their job is to say, is there a reason for this, the way that you've particularly struck this balance? If there is not a reason, if it cannot be justified, then we have to say so. And that's that kind of demanding of evidence and reason giving that I think renders this judgment, or the role of courts in this area a useful one. But it is, it is always a matter of deciding, or in every case, you have to look at the specific measures and decide whether the balance struck is the right one. But I think usefully, the courts do have a role in these kinds of cases. And in times of crisis and emergency and war, those are the circumstances in which human rights are at, I think, the greatest risk, because the justification or the reason for taking measures that are restrictive of human rights is a strong one. And so really, those are the circumstances, I think, that we need courts to be vigilant in order to ensure that the state has enough latitude to do what it needs to do to protect the community and general interest, while not going further than it needs to in order to protect individual rights. But thank you for the question.
There are a lot of questions about what's going on at the moment with protests during COVID and things like that, and how you think that actions of the police maybe would impact on human rights. I don't know if you want to speak about any of that, but can you briefly touch?
Well, I think it's certainly an issue that concerns human rights. So, as I mentioned, freedom of assembly is one of the rights that we have under the European Convention on Human Rights. It's very difficult, as I said at first, to assess in the abstract without knowing the exact circumstances. But I think it will be looked at through that lens, I think I would say. And yeah, I think it will be reviewed in that way.
Yeah, too. And then maybe just to end then on, so there's a question about both of your roles. So did you ever have to argue in court, and what did you find it the most enjoyable in both of the roles?
Sure, thank you. So in my work, I did a training contract at a solicitor's firm, and I think the most enjoyable thing about that was feeling part of a team and getting to work on some pretty high profile transactions and arrangements and some rather high profile litigation. And you're working, the structure in a solicitor's firm is there's a partner, an associate, a number of associates, and then the trainee solicitor. And so you work together with your colleagues to achieve whatever it is. If it's a transaction, to achieve what your client wants to achieve in the transaction. Or if it's litigation, obviously you either defend your client's interests, or you find the arguments that they want to make against someone who will be defending their own interests. And so that kind of work can be really, really varied and really interesting. And I remember a couple of times when we were working on these kinds of big commercial deals, or we were preparing witness statements for a deadline, and there gets to be this kind of community spirit. We're all driving towards the same aim, and you sort of keep each other going in the moments when it could get a bit tough. And so that kind of camaraderie within a solicitor's firm was a really nice thing to have seen. And then on the barrister front, well, for me personally, I really liked the nature of the work. So I did seats. You sort of rotate when you train, or some chambers do. I did seats in employment law, media law, and public law and human rights. And so for me, the subject matter of the work and getting to see courts make decisions in these areas was the most interesting thing, because I could really grapple with the arguments before the case had been decided. And I think it's just it was a great experience to see that. And yeah, I think so. For me, it was the subject matter when I was training to be a barrister, and the kind of personal experience and camaraderie when I was working as a solicitor. That's what I would say were my favourite parts to it. But both very, admirable, worthwhile career options.